estate. I'm surviving. I'm gonna have my own, and she's gonna have her own. 33, 33, 33. You got it? Again, can you read?
Upon the death of any one of the joint tenants in a joint tenancy, the surviving joint tenants become the owner of the deceased interest.
This is a general principle.
There is an exception to this rule when a married person dies owning a matrimonial home as a joint tenant with a person who is not his or her spouse.
My mother. Me, my mother.
Section 26 of the FLA states that the joint tenancy is deemed to have been severed immediately before the time of the death, in effect creating a tenancy in common.
In three people. My surviving spouse, me, and my mother estate. Or if I'm gonna die, my estate. Tenancy in common. Describing the property. Okay, describe the property. यार, sorry. Sorry,
नहीं नहीं सर तबीयत खराब है आपकी
हैं? Riga हंस रही है, क्यों हंस रही है? क्यों हंस रही है?
पता नहीं सर, मैंने तो देखा भी नहीं कौन.
No problem. Okay, describe the property. Lot of time is a question. Describe the, what is the first component to describe the property? What is the first component to describe the property? Municipal address is the first component. Second paragraph, first line. 70. I need your attention. In my last class, people always tired.
Nothing but energy.
Look at her health, man. She's so skinny.
Sir,
Okay.
I'm fit, I'm not skinny.
Okay. So if municipal address is the first component. So what was the question?
First component. I mean, important thing.
Describe the
how
first.
are you going to describe the property? So
What is the
most
first
important
component to describe the property?
Municipal
address.
Rata. Okay. Determining the property. This is also very important. Determining the property. Can you read?
3.2.
Yeah.
The persons drafting the agreement must determine the dimensions of properties boundaries from a survey, a reference plan, or registered plan of subdivision, or the seller's registered.
This is also important.
Transfer
I don't know
deed.
what kind of important, but it's important paragraph. Okay, more or less. Second, minor inaccuracy in dimension, more or less. What's that mean, more or less?
Then if the dimension is like
More or less.
More or less. Like some
then the
encroachment
yeah.
on your property is justified. Okay, it's
A little bit.
little bit justified.
If your
My
fence
tree
goes into the next door.
into the next door.
fence, whatever.
Okay.
If Monica lives there, then.
Okay, so this is justified, right? The question is, whenever you buying a land for development,
Yeah,
then
you need a specific dimensions, whatever.
I have to
dimensions.
delete more or less.
Yeah.
Whenever you are buying a land for development, because in development or small houses, I have to demolish and make a bigger one. This kind of question. Whenever, always being a lawyer, you have to give me advice. More or less, column should be deleted.
It should be very accurate.
It should be very accurate. More or less should be deleted. Otherwise, there is no claim. Whenever you are buying a land for development, always more or less must be deleted. Being a lawyer, you have to give me advice. All right? Okay. Now you can read.
The dimensions of the land.
No, buying land for development.
3.4, buying land for development. In the case of a property being purchased for development, such as a vacant land or land having an old home to be demolished, the buyer must know the minimum lot areas, street frontage, building setbacks, and other criteria specified in the municipal zoning bylaw. These specifications in turn determine the number and the size of the home that the buyer may build on the land. For example, a home builder may buy a large lot containing one house, intending to divide a lot into 3 smaller lots and build a home on each new lot. The total area of the land being purchased is square meters, acres, or
I don't know. I
hectares.
have a different old book. See, so the buyer should delete more or less
It's here.
from the
Such
plan.
a
There.
buyer should do it. It's the same thing.
You
Go
go,
ahead.
you go down and it comes.
Hmm.
Such a buyer.
Along with the length of its frontage on a public street and depth are critical to this buyer purpose. On the basis of these requirements and the bylaw requirements, the buyer can plan to build a specific number of homes of a certain size and will value the land accordingly. Such a buyer should delete more or less from the
Highlight.
form, modify the description of the land to suit its
Point to be noted, whenever being a lawyer, you have to give me advice. You know what? I'm your client. I came to your office. You are a lawyer. So you know what? I wanna buy a land for buying a land for development purpose. So you have to give me advice.
That more or less
Delete
was
more or less.
multiplied.
This is a general default provision, more or less. But in this given scenario,
Delete it.
delete it. And then second last paragraph. I don't know which one. This one.
Is the actual a similar example? as the buyer? We don't have it.
So don't worry about it.
Yeah, we don't have.
It's okay, no problem. So I'm gonna update my book. Okay. Then next one, legal. Okay, just hold on. Okay. Then go into 3.6. 3. Huh?
Disclosing known latent physical defects.
Do you know what's that mean?
Yeah.
What's that?
Which are apparent, like,
Obvious.
The second paragraph. The second paragraph is important.
should I read it?
Yeah.
A patent defect is one that is readily discoverable either by a buyer or a buyer's professional.
Like anything gonna happen with this property, maybe someone was die, murder, anything gonna happen with this property.
That is stigmatized.
That is stigmatized.
Yeah,
If
that wouldn't
if that
be-
is murder, then it's stigmatized,
Nice.
right?
Yeah, that is not a latent
Patent is
defect.
something
Latent is
obvious.
patent is something that you could see.
I know
when
what
you
that.
walk into the
Yeah,
house.
yeah.
If you see
But
the-
okay. But keep continue. Okay.
Sure.
No problem. Just keep continue.
A latent defect is unknown to the buyer and presumably to the seller and is not easily discoverable on a physical inspection, including an inspection by a professional.
Can you see in a recent year?
Yeah.
Oh, yeah, last part.
Okay.
Should I read that one?
Yes, please.
In recent years, a similar issue has arisen as to the seller's obligation to disclose in the agreement information about the history of the property and the surrounding neighborhood that may materially affect the value of the end or desirability of the
Very
property.
important.
Yeah.
The issue of intangible subjective or non-physical stigmatization of the property raised similar concern to those involving latent physical defect. Example includes the past use of the property for criminal purposes, the fact that a notorious murder or death occurred in the house, and the fact that a convicted pedophile lives down the street. Circumstances of this class have to.
This is also called as this one. You got it? So that's it. This is important, right? Okay. Makes sense, right? Okay. Jump into deposit. Okay. In deposit, sometimes one question come from deposit. Deposit mean, okay, you are seller, I'm a buyer. He's your lawyer, he's my lawyer. You are selling, I'm buying. So I have a lot of money. Where money gonna deposit?
Trust it.
Trust account to.
The seller's lawyer.
Seller's lawyer.
lawyer.
So who is seller? You are seller. You are selling. If you are selling, okay, I have to give you money. So my money gonna go into your
Lawyers.
lawyer's
Lawyer's
trust
account.
account.
Trust account.
Lawyer's trust account. First step. Lawyer is not involved.
Then brokerage.
Then brokerage is involved. Listing broker.
Or the agent who-
Yes. So read from the third paragraph.
There are three alternatives provided in the ORIA form respecting the payments of deposit. First, it may be presented with the offer. Second, it may be paid upon acceptance, which is defined term, or Third, it may be paid as otherwise described in this agreement, Section 17 of OREG 57, whatever, made under the Real Estate and Business Broker Act 2002. Requires that a broker place the deposit in its trust account with within 5 banking days of receipt.
Don't worry about within 5 days. Don't worry about. There is no timeline in solicitor. Timeline is only for
Barrister.
barrister.
So they don't ask you any date questions?
No.
Or nothing?
Whatever they're going to ask you, I'll let you know. Don't worry about it.
Thank you, sir.
As a result, it is possible for an agreement not to be accepted, but